Hi, welcome to this Law Study Club tutorial for A-Level Law on causation. Causation is a really important concept in criminal law that needs to be considered whenever you're looking at any consequence crime like the fatal offences ABH or GBH. In this tutorial we're going to start with factual causation and then move on to legal causation, thinking about how legal causation works, the thin skull rule, and finally the chain of causation. When a defendant is charged with causing a particular consequence, like a victim's death or really serious harm, the first element of causation the prosecution has to prove is called factual causation. To work out whether the defendant's acts or omissions were the factual cause of the outcome, the courts apply the but-for test. This test establishes whether the prohibited consequence would have happened if the defendant hadn't acted as they did. If the prohibited consequence would not have happened but for the defendant's actions, there's factual causation. A useful case to demonstrate factual causation is R.V. Paget from 1983. The defendant used his girlfriend as a human shield during a confrontation with armed police. While he held his girlfriend in front of him, the defendant shot at the police officers. They returned fire and it was police bullets that killed the defendant's girlfriend. The defendant was prosecuted for her manslaughter. For now we're going to stick with the question of factual causation in Paget. Try putting the words but for into a sentence in relation to Paget's actions and his girlfriend's death. But for Paget using his girlfriend as a human shield, would his girlfriend have died? The court decided she wouldn't have died but for Paget's actions, so his actions were the factual cause of her death. A case that demonstrates the same question but with a different outcome is R.V. White from 1910. In White, the defendant put poison into his mother's evening drink, intending to kill her. She drank a few sips and fell asleep, and while she was asleep she died, but the medical evidence said that she died from a heart attack and not from poisoning. The defendant was prosecuted on a charge of murder. Again, put the words but for into a sentence with White's actions and his mother's death. But for White putting poison in his mother's drink, would she have died? Here we get the opposite outcome to the decision in Paget. Because White's mother died from a heart attack, it was decided that but for White putting poison in her drink, she would have died anyway. This meant that White's actions were not the factual cause of his mother's death and he was not liable for murder. So our key rule on factual causation is that it's tested using the but-for test, which asks whether the prohibited consequence would or wouldn't have happened if the defendant hadn't acted the way they did. It's a good idea to practice using the phrase but for in the way we've been using it here, because it's the clearest way, with support from Paget or with support from White, of applying the test of factual causation to a scenario question in the exam. Now, factual causation is an important starting point and it must be proved for the defendant to be liable. But factual causation only gets us so far. There are loads of circumstances when, if we only used the but-for test, defendants would be liable for things they didn't cause in any meaningful way. Imagine a scenario where I knock into someone while I'm rushing to catch a train in the morning. The person I knock into spills their coffee down their shirt, then they have to change their plans to buy a new shirt on their way to work. After buying their new shirt, they slip down the shop's escalator and they suffer serious harm. If we just use the but-for test, I could be criminally liable for their serious harm. Because but for me knocking into them in the first place, they wouldn't have needed the shirt and they wouldn't have been in the shop and they wouldn't have fallen down the escalator. But it would seem a bit ridiculous to hold me criminally liable for it. This is why we need legal causation. If factual causation can be proven, the prosecution then has to prove legal causation too. And for legal causation, we're trying to work out whether the defendant's acts or omissions made a big enough contribution to the prohibited consequence for them to be liable for it. Legal causation is particularly important when an outcome seems to have more than one cause. R.V. Hughes is an important case for causation, and it's a useful case because we can use it to explore factual causation and also legal causation. So the defendant in Hughes was not insured and didn't have a full driving licence. He was driving his camper van faultlessly along a road. He was on his side of the road and he was within the speed limit. As he went round a bend, a car came onto his side of the road and hit the camper van. The driver of the other car was under the influence of heroin and died as a result of the accident. The defendant was prosecuted for causing death by driving without a licence. At trial, he was convicted. If we start with factual causation, we find that the question of whether the defendant's acts or omissions were the factual cause of the victim's death is a bit of a complicated one. On one hand, but for Hughes getting in the car and driving when he didn't have a licence, the victim wouldn't have died because the crash wouldn't have occurred. On the other hand, but for Hughes not having a licence, in other words, if he did have a licence, the victim would still have died because Hughes's driving was faultless, so he wouldn't have been driving differently even if he'd been trained and had a licence. This makes the question of legal causation particularly important. So Hughes was charged with causing death by driving without a licence. So the Supreme Court had to decide whether Hughes driving without a licence was an important enough factor in the victim's death to make him liable. The Supreme Court decided that it wasn't and overturned Hughes's conviction. Hughes not having a licence was a minimal cause of the victim's death and not enough to be a legal cause. The Supreme Court used the opportunity to reiterate that to find legal causation, the defendant's behaviour has to make more than a minimal contribution to the prohibited consequence. The next key rule of causation can be found in R v Blau. In Blau, the defendant stabbed the victim. The victim was told she needed a blood transfusion to save her life, but she refused the transfusion on religious grounds because she was a Jehovah's Witness. The victim then died as a result, and the defendant was charged with manslaughter. The question here is whether the defendant should be liable for the victim's death, even though the victim might have survived if she'd accepted the blood transfusion. The same question arises when a victim suffers more serious harm because they have some kind of pre-existing medical condition that makes their injury worse. On one level, it seems harsh to the defendant to hold them liable for the full extent of the victim's harm. However, this is where the thin skull rule kicks in. The thin skull rule means that a defendant must take his victim as he finds them. In other words, if the victim has a pre-existing condition, or in this case a religious belief, that makes their harm more serious or even fatal, the defendant is still liable for the full extent of the injuries caused. The rule makes sense when we put it together with the rule from Hughes that the defendant's contribution to the harm just needs to be more than minimal. In Blau, the case on the screen, while the defendant might feel that he shouldn't be liable for the victim's death, it's pretty clear that when he stabbed her, he made more than a minimal contribution to her being killed. So this gives us our first key rules for legal causation. To be a legal cause, the defendant's conduct must be a cause that's more than minimal, reiterated in R v Hughes. Now, judges have found different ways to explain this more than minimal rule to juries, and one explanation that's been supported on appeal is from R v Kimsey, where the judge explained to the jury that there must be more than a slight or trifling link between the defendant's conduct and the prohibited consequence, and you can choose in the exam whether you'd rather support it with R v Hughes for more than minimal or R v Kimsey with more than a slight and trifling link. And finally, the thin skull rule means that if the victim has a pre-existing medical condition or a characteristic that makes an injury more serious than it would be for most people, the defendant is still liable for the full extent of their harm. Now, the final concepts that will help us to work out whether there is legal causation are the chain of causation and intervening acts. The chain of causation is a phrase we use to describe the events that take place between the defendant's conduct and the harm that's eventually suffered. Sometimes the chain of causation might be very short. The defendant shoots the victim in the head and the victim dies instantly. But very often the defendant's act or omission isn't the last thing that happens before the eventual harm is suffered. For example, imagine a defendant punches the victim in the face. The victim turns to run away from the defendant but trips over a curb and falls into the road. A passing motorcyclist is distracted by a sudden flash of lightning, so he hits the victim and the victim dies. Now, all of this could happen in the space of a few seconds, but there are lots of steps between the defendant punching the victim and the victim's death. And so we use the chain of causation to describe these steps and to look for whether there are any intervening acts that break the chain. An intervening act, sometimes called a novus actus interveniens in Latin, is an act that breaks the chain of causation and removes the defendant's liability. An intervening act can be the act of a third party, the victim's own act, or a natural unpredictable event. Now, the act of a third party means an action by someone other than the victim or the defendant that somehow contributes to the eventual outcome. So in our story, the motorcyclist is a third party. The victim's own act means that the victim does something themselves after the defendant's original attack that somehow contributes to their harm, such as when our victim turned to run away and fell down the curb. A natural, unpredictable event, which used to be called an act of God, means something over which nobody, not the defendant, not the victim, and not a third party, nobody has any control over, that contributes to the eventual harm, such as the sudden flash of lightning that distracted the motorcyclist. However, to break the chain of causation, any of these intervening acts must be sufficiently independent of the defendant's conduct and sufficiently serious. In other words, it can't be a foreseeable reaction to the defendant's conduct, and it must be serious enough to overtake the defendant's liability. In our three examples, it's likely that none of the three, not the victim turning and falling off the curb, not the motorcyclist's actions, and not the flash of lightning, none of them would be sufficiently independent of the defendant's conduct or sufficiently serious to break that chain of causation. We'll start with a case that shows us the victim's own act as a break in the chain of causation. In Williams and Davis, the victim died after jumping from a moving car when he thought the driver and his friend were trying to steal his wallet. The question for the court was whether the victim's decision to jump from the car was sufficiently independent of the defendant's alleged theft and sufficiently serious to break the chain of causation. The court decided that it was both. It was independent of the defendant's actions because jumping from the car was not a reasonably foreseeable reaction to an alleged theft. And it was clearly serious because it was the jump from the car that gave the victim the fatal injuries. The Court of Appeal, slightly harshly possibly, described the victim's reaction as so daft that it broke the chain of causation. You might remember that you can contrast this case with R.V. Roberts, in which a woman's decision to jump from a moving car to escape a sexual assault didn't break the chain of causation because that was a reasonably foreseeable reaction by the victim, and in that case, in R.V. Roberts, the defendant was liable for the full extent of her harm. If we move on to a case that demonstrates an act of a third party, in R.V. Paget that we considered earlier, the police officer is a third party. The question is whether the police officer's decision to fire that fatal shot was sufficiently independent and sufficiently serious of what Paget was doing in order to break the chain of causation and remove Paget's liability. Now, I think we'd agree that the police officer firing a fatal shot is pretty serious. He was firing a gun at two people, after all, but it wasn't sufficiently independent of the defendant's conduct. The only reason the police officer was firing at Paget and his girlfriend was because Paget was firing at the police officers. So it was held that didn't break the chain of causation, and Paget was still liable. The police shooting was a reasonably foreseeable response to Paget shooting at them, so it's not sufficiently independent of Paget's conduct. Now, often the third party that we're talking about when we're dealing with the chain of causation is a medical professional, like in R.V. Smith. So in Smith, the defendant stabbed the victim in the lung, and while the victim was being treated, the stretcher he was being carried on was dropped, and then the victim was given CPR incorrectly, which made the injury much worse and decreased the victim's chance of survival by around 75%. So the victim died, but the defendant, who originally stabbed the victim, was charged with murder. Now clearly, the medics have contributed to the victim's death in this scenario by making it much more likely. The question is whether that's enough to break the chain of causation and remove the defendant's liability. It was held that in this case, the poor medical treatment, even though it was extremely poor, isn't an intervening act that breaks the chain of causation. And that's because the defendant's act of stabbing the victim was still an operating and substantial cause of the victim's death. Another way we could think about that would be to say that the intervening act has to be sufficiently independent and sufficiently serious of the defendant's original act, and we could say that the poor medical treatment here isn't sufficiently independent of the defendant's act because all they were actually trying to do was to treat the original stab wound, even though they were doing it poorly. So the poor medical treatment here doesn't break the chain of causation. R.V. Jordan, though, gives us an exception to that general rule that poor medical treatment doesn't break the chain of causation. So in Jordan, we have another stab victim. While he was in hospital, the victim was given an antibiotic to which he suffered an allergic reaction. So one doctor noticed the allergic reaction and stopped the use of that antibiotic. but then another doctor came on, failed to read the notes and administered a large dose of the same drug, and the victim then died from an allergic reaction. Now we could see this as the doctor still trying to treat the wounds caused by the original attack, and we could apply the rule from Smith that poor medical treatment doesn't break the chain. But in fact here, the courts decided that the doctor's actions did break the chain of causation, and the defendant wasn't liable for the victim's death. Because the antibiotic had been removed and then prescribed again by a doctor not reading the notes, this made the second doctor's actions sufficiently independent and sufficiently serious to break the chain of causation. So this gives us our second set of key rules on legal causation. The chain of causation can be broken by the victim's own act, by the act of a third party, or by a natural unpredictable event. But one of these new intervening acts only breaks the chain of causation if it's sufficiently independent of the original act and it's sufficiently serious. The intervening act doesn't break the chain of causation if it was foreseeable by the defendant at the time of their act or omission, like in R.V. Roberts or R.V. Paget. And poor medical treatment, even very poor medical treatment, doesn't break the chain of causation unless it's completely independent of the original injury. So now work through this scenario to check your understanding of causation. Alan pushed Barry during a rush to get to the front of a queue. Barry fell and cut his leg. Barry had haemophilia, meaning that his blood didn't clot effectively. While waiting for the ambulance, Barry lost a lot of blood. The paramedics failed to notice the extent of Barry's blood loss and didn't stop the bleeding until around 15 minutes after they arrived. When he arrived in hospital, doctors then wrongly decided that the only way to save Barry's life was to amputate his entire leg. Now remember to think about factual causation and legal causation, including the chain of causation and any intervening acts. So would Alan be liable for all the harm to Barry, including the amputation? Remember to back up your thinking with points of law to support it and cases that provide authority for your points. So you should now be able to explain the but-for test for factual causation, apply the concept of legal causation, including where there are multiple causes at play, where the victim has a pre-existing condition, where there's a chain of causation between the defendant's conduct and the eventual harm suffered. Hit subscribe to get notifications on new tutorial videos and follow the link in the description to lawstudyclub.co.uk, where you can find up-to-date revision guides and unit summaries for the OCR and AQA specifications, or to inquire about tutoring for A-level law.